let's talk about what does it take to because this is this segment is directed at attorney Max Solomon, who is running for mayor of Hazleton, if I'm not mistaken. So let's talk about attorney Max Solomon. All right. I was going to do a thumbnail for a video, but I just probably edit this one. But we have to talk about Tiffany Henyard's attorney Max Solomon. What does it take to generally be a good or competent attorney, and why he seems to me, in my opinion, and I mean, we graduated law school around the same time, so I'm just confused why he continued to make bad legal mistakes. These aren't mistakes that somebody who's been in the game over a decade, I think he graduated in 2012, should be making. Okay, so all right, first of all, background, just so everybody's up to speed. We did a video. We talked about why we actually looked at uh, the bar association's order on their decision to suspend attorney Max Solomon. Long story short, for those who haven't saw that video, when he originally graduated law school in 2012 after passing the bar, he had a job at a local school system. It may have been a community college or something to that effect. He took on some legal work for his supervisor as a favor. A part of that condition was, yo, you don't even got to pay me. I'll handle it. And he did absolutely nothing. He didn't file the appropriate paperwork. He didn't inform his clients of what was going on in court. He misappropriated, I think it was $12,400. He had no clue of who he actually represented as a client. He was taking money from his clients, who was his supervisor. It was a property matter, and the property at issue was subject to litigation because it may have been owned by attorney Solomon's client, or it could have been owned by another individual. So while this litigation was going on, she had a tenant in the house. The tenant was paying the rent. This was the one thing he did right. He set up an account so that the rents that the tenant paid would go into this account. And once the court make a determination on who the owner of the property was, that money would get dispersed to the owner. But of course, he took money out of there. He actually charged the tenant, not his client. He told his client he would do it for free. He actually charged the tenant for legal services when he wasn't doing shit for the client. He had no agreement, no paperwork to establish any type of attorney client relationship. So essentially, the bar association was like, bro, you didn't do shit. Now, this was in 2012, 2013, 2014, I think up to 2017, this process was going on. Well, essentially, what happened is it didn't get into the bar's review until now. And if you actually go back and watch that video, I'll put the link in the comments. I'll pin it in the comment of this video. He was even disingenuous now about his conduct back then. We just were able to read that opinion and poke so many holes in his story. But the court decided, you know what? We're going to issue this suspension. If you can engage in these particular activities, we'll remove your suspension. But they put a lot of conditions on him. That was just the background. Okay. So he started off on the wrong foot. The court was like, well, the bar who reviewed this essentially said he didn't have a mentor. He didn't know what he was doing. Even though his excuses for why this shit happened is some BS, we're going to give him the benefit of the doubt. Me personally, I told y'all I would have snatched his license. Once you play with somebody, money is the rap for me. That's how most bar associations work. So I'm actually shocked that they gave him an opportunity to keep his license. So he started out on rocky ground. Now, fast forward, we were doing the last live stream. A few of you all left in the comments, and I was like, is this true? Let me look in open source to see if this is accurate. Essentially, he was informed by the court that he actually needed another attorney present during the course of all of the litigation. So now, if this is accurate, there are very few instances where the court requires an attorney or an individual before the court who's an attorney to have another counsel present. Okay. One is, I've done this before and it was annoying. If you are still a law student, third year practice rule. So you got an intern who's in their last year of law school. They want to litigate cases in front of the court. Under the third year practice rule, it's called different things in different states, but under the third year practice rule, that individual could actually litigate cases, go before the court, as long as they're accompanied by a licensed attorney, which is me. It's cool to do for them. It's a burden for me because now I got to be here in the courtroom when I could be out doing something else. That's example number one, where an individual before the court would need an attorney present. Okay, even though he may perform work that of an intern, he's not an intern. This dude graduated back in 2012. Okay, so he's not an intern. The second scenario is, it's called pro hoc vice, and some of you may know this term, but it's for this matter only, for limited purpose. So an example of when an attorney would request to will request to practice before the court pro hoc vice is in a very limited situation. Most times that happens, and attorneys like to use Latin to sound like they know what they talk about, inter alia and res ipsa loquitur. But anyway, pro hoc vice essentially means for this matter only, or for this limited matter only. So the second example of when an attorney would need co-counsel present to appear before the court is if they're appearing pro hoc vice. An example of that would be, let's say my brother got incarcerated in a neighboring state, or was charged with a crime in a neighboring state, right? If he's charged with a crime in a neighboring state, I'm not licensed in that state. I'm licensed in other states, but not that particular state. Well, I can go before the court and I can put a motion into the court and ask the court, hey, Your Honor, I'm requesting that the court allow me to represent my client on this matter pro hoc vice, just for this matter only. And the court can say no or say yes. Most times, if the court does say yes, they'll actually require that attorney to work with local counsel. So, and how it works on the attorney side of the game, you end up having to pay somebody. If I'm a attorney and I represent people in car accidents, and someone gets in a car accident in Virginia and I'm not licensed in Virginia, but they come to me, I can pass that case off to an attorney in Virginia and get a little bit of a kickback finder's fee, or I can actually ask the court to represent that person pro hoc vice, and that court will say, hey, you need to get an attorney barred in Virginia so you're aware of all of our rules and local rules and how we do things. And me, I would still have to kick that attorney some money because that attorney, his name is going to be on the record. He's probably going to have to sign all of the pleadings and all the documentation with me. So those are the very limited situations where a person can practice before the court, but the court will require you to have another counsel. Neither one of those would apply in this situation. This is somebody who is barred in the state where he's currently engaged in the practice of law. So it would be odd and weird as hell for the court to ask somebody who's been practicing for fucking 15 years, like, yo, you need another attorney. If that is the case, okay, if that's the case and the court is like, yo, you can appear before the court, but you need to have another bar counselor with you, it's not because he's an intern. It's not because he's not barred there and he's asking to represent Tiffany Henyard on a limited basis, pro hoc vice. It's because the court don't think he know what the fuck he doing. That's just what it could be. Nothing else. That has to be the only reason why I would say, hey, you make sure you here with somebody else because you don't really know what the hell you doing. So it to me, it's given. I don't know. I, I don't know. I think that's kind of wild, but that's the only thing that makes sense. It's definitely not the first two. You have to appear before the court with another attorney is because the court has caused a pause with your ability to actually engage in the practice of law. Now I want to go ahead and pull up this article so you all can see exactly what the hell I'm talking about. And this actually pissed me off. Shout out to everybody in the chat as well. I appreciate y'all tuning in. We're gonna try to go through some of them, but I wanted to get through this. Let me go ahead and I remove that. Let's see. Stop sharing that screen. We want to share this article right here. All right, remarkable women nominated in your community. That's funny. We talk about a non-remarkable, a woman who isn't remarkable, and that just happens to pop up. All right, let me see. Oh, let me see if I could. Let's do no thanks. Let's see if we can make close this out. All right, let's see if we can make this larger, just in case you all want to read with me. All right. So this is about the appointments that have fell through, and this is interesting. You good? You eat some? Uh, You ain't gonna do that pizza then? Yeah, I'm on a live. You want to come say hi? You ain't been on here since you was like in middle school. I don't know if nobody can hold on. They probably can't. My camera don't go all the way over there.
Yeah, I know it
All they
does.
see is
I
your.
know it does. It
All
is
they see is
TV.
your. Let me see. There you go. Look at it. I know this dude got dreads now. Look at my little future lawyer. He don't know it yet. My little future lawyer. This dude all grown, voice deeper than mine. All right, let's go and jump into this. My bad. I got distracted. All right, let's jump into this. This is an article about the appointments that the judge said, yo, you can't appoint these people. And we'll talk about that. But let's focus on how terrible of an attorney Max Solomon appears to be. All right. Let me get a little bit swig of grapefruit juice. All right. A Cook County judge has violated Mayor. Oh, excuse me, I can't even read. A Cook County judge has voided Mayor Tiffany Henyard's pick to serve as village administrator, attorney, and police chief of South Suburban Dalton. It's the latest power struggle to end up in court. Judge Thaddeus Wilson said Henyard lawyer chose not to file an answer to trustees' complaint that she was acting beyond her authority to appoint people for key village positions without their advice and consent. Worst lawyer ever. That dude is the worst attorney ever. My bad. I forgot to change the view back. But that paragraph, that sentence right there proves to me that he is the worst attorney. I don't even know. I don't know. This is ridiculous. Let me run it back. Just Thaddeus Wilson said Henyard lawyer chose not to file an answer to trustees' complaints that she was acting beyond her authority to appoint people for key village positions without their advice or consent. Excuse me. Without their advice or consent. There are two reasons that a person or attorney would not file an answer to a complaint. But just so you're all aware, that's actually stage one of litigation. The very first thing I'm going to do if I want to sue you, I'm going to get your information. I'm going to go down to the courthouse. I'm going to file a complaint. I'm going to pay the sheriff $7, $20, $30, whatever it is. So that sheriff serves you with that complaint. Now you have notice of a lawsuit. And now most times you have 30 days, 45 days, depending on where you at, to file an answer to that complaint. My complaint lays out how you violated my rights of the law. Your answer lays out how my complaint is capped. Is this your complaint is frivolous or your complaint is facially invalid because of these particular reasons? It's this literally the second step in the process of filing litigation. So why would an attorney not file an answer? Well, it's two reasons. Reason number one is you don't have an argument for shit. And if that's the case, it means your lawsuit was frivolous. And if I was the judge, I would I light your ass up. But if I don't file an answer to a complaint for my client, One option could be I don't have any legal arguments, which should never happen. I don't care what you sue somebody for. I'm going to have an argument. Now, is that argument going to be a strong argument? That argument may not be strong, but I'm going to argue something. I'm going to argue something. I'm going to find some case out there. I don't care if it's from 1875, back when politicians used to wear wigs and shit, but I would find something. So that shouldn't be an option, but you could not file an answer because you don't have any legal argument. Again, if that's the case, that means you suck as an attorney. So you should have an argument for absolutely everything. I've never, I've had cases where the facts were definitely not favorable for my client, but I came up with an argument. I've actually won cases where I came up with arguments and I said, shit, I'm gonna pull this argument out of left field. And sometimes the left field argument can be substantiated with the facts. So that shouldn't ever happen. It should never be a situation where an attorney doesn't file an answer to a complaint because he couldn't think of anything. If that's the case, you shouldn't be an attorney. Okay. The other alternative is, which could also be possible, the other alternative could be he took a track record and a page out of his early book when he was first practicing and he just fucking forgot and didn't do shit. Either one is terrible. Each option is evidence of you being an actual terrible attorney. Okay. Now, which one is worse? It's worse to forget and just not file anything. No, no, it's actually worse. Honestly, which one is worse? It's actually worse not to be able to come up with any type of legal argument. That's actually worse. I would actually rather my attorney forget to do some shit because if he forgot to do some shit, I could always get a remedy from the court for his incompetence. So that's we can rectify that. But not filing an answer because you can't come up with a legal argument is is absolutely ridiculous. All right, let's go back through this article. All right, just the randomest shit be popping up. All right, it goes on to say that Henyard's pick for village administrator Michael Smith and village attorney Angela Lockett can also not act in those capacities. She's not an empress, she's a mayor, said Bert Odelson, who represents trustees opposed to Henyard. She needs to follow the rules. Mayor Henyard proposed the agreement and all parties agreed to it. Henyard attorney Max Solomon said Mayor Henyard will continue to pursue and follow all her legal options and procedures as clearly agreed in the order. Henyard's battle for control of the village key positions has paralyzed many operations. WGN investigates his documented concern about Henyard's spending leadership, both in Dalton and Thornton Township. Federal investigators, blah, blah, blah. This week, Henyard closed and locked Thornton Township building amid an ongoing dispute with trustees. With trustees who have boycotted meetings to block her ability to appoint new trustees to replace an ally who resigned from the board. Henyard is suing Township Democrats who blocked her from participating in a caucus to select who would appear at the top of the ticket. She also faces a re-election battle for the mayor of Dalton this spring. All right. Max Solomon might be the worst attorney. I don't know. I ain't gonna say he's the worst attorney, but he's definitely. I wouldn't hire him as my attorney. Let me go and check out some of these comments real quick. I'm gonna see what we got here. Yeah, yeah. Let's see. Oh, I appreciate you. I'm glad you was able to catch it. I'm glad you was able to catch it. All right, the big bingo. It's free to join. We all in the bingo cards on the bingo. Let's see. Uh, okay. I'll look into that. I'm not gonna check it out now because normally I could go long as hell, but I can't go super long tonight. on this. All money ain't good money. Max needs a job. What are you gonna do? Like I don't know. I don't know what I don't know what I don't know. I don't know. I just I don't know. It's I can't fathom a situation where an attorney who's been licensed since 2012 didn't file an answer to a complaint for his client. Like that shit just don't make any sense to me. Yeah, the attorney, and that's the other thing that's weird. The lines of which attorneys represent who and whose interests are just completely crossed here. Because, like, the office of the mayor should have a general counsel. That's how it is in most places. The office of the mayor has a general counsel, and that general counsel has associate attorneys who do all this other shit. And anything that comes up related to the operation of the office is general counsel shit. Anything that comes up related to the operation of you is your shit. And you have to actually pay for an attorney to handle that. But the lines are really blurred.